Good morning. I want to start by thanking the National Religious Campaign Against Torture and the American Civil Liberties Union for holding this press conference, but also for inviting me in my capacity as Special Rapporteur on Torture for the United Nations to address you all. Solitary confinement remains a pervasive problem throughout much of the world, and in many cases is subjected to widespread abuse in violation of international human rights norms, including the prohibition of torture and ill treatment. Unfortunately, the United States is one of the countries where solitary confinement is most widely used for prolonged periods of time and raising significant concerns regarding compliance of this practice with the United States obligations under the International Covenant for Civil and Political Rights and under the Convention Against Torture. Both treaties have been signed and ratified by the United States. As it has been repeatedly stated by universal and regional human rights mechanisms, solitary confinement can amount to cruel, inhuman, and degrading treatment or punishment, and even amount to torture. This is a case where the implementation of a practice fails to respect the inherent dignity of the human person and causes severe mental or physical pain or suffering. Evidence suggests that serious health effects may begin to appear after only several days of isolation, including certain psychotic disorders, anxiety, anger, depression, cognitive disorders, and paranoia. According to official sources, a majority of the roughly 80,000 persons held in solitary confinement in the United States in any given day are held in isolation for prolonged or indefinite periods. In California alone, an estimated 10,000 persons are being held in solitary confinement, many for prolonged periods. In the report I presented to the United Nations General Assembly in 2011 on the issue of solitary confinement, I defined prolonged solitary confinement as any period of isolation exceeding 15 days. I chose a standard based on research that identifies 15 days as the point at which many of the harmful physical and psychological effects of isolation can become irreversible. Because of this, I find that the use of prolonged solitary confinement should be prohibited at all times, as it constitutes cruel, inhuman, or degrading treatment or even torture. This is not to say, however, that isolation lasting for 15 days or less is always justifiable. All instances of solitary confinement should be assessed on a case-by-case basis, taking into consideration all relevant circumstances, including the purpose of its application, the conditions, length, and effects of the treatment, and the subjective conditions of each individual. In this sense, special attention needs to be paid to the particular context and justifications for the imposition of solitary confinement. Although the use of short-term solitary confinement with appropriate monitoring may be sometimes legitimate, the practice cannot be justified as a form of judicially imposed sentence or disciplinary regime, or when it is applied solely on the basis of the gravity of the crime of the offense for which the inmate has been convicted. Additionally, when applied as a prison management measure, such as in cases of separation of suspects of association with gangs, it deprives the inmates of their due process rights to challenge the decision, and it may become a punitive measure which can easily be abused by guards and authorities against certain inmates. The same conclusion may be extended to the use of solitary confinement in pretrial or preventive detention, where such practices create a de facto situation of psychological pressure which can influence detainees to make confessions or statements or to plea bargain, and raise the risk that acts of torture or ill treatment will go undetected and unchallenged. Furthermore, in recognition of the special vulnerability, the use of solitary confinement of any duration with regards to juveniles, to persons with mental disabilities, or to pregnant women should be strictly prohibited. Fortunately, there have been some serious efforts to address this issue in recent months that I would like to publicly welcome. Such is the case of the state of New York, that has agreed to implement a minimum of 5 hours of outside cell programming. I have also been informed of other positive developments in other states, including Maine and Mississippi, where actions have been taken to safeguard prisoners, particularly juveniles, from the detrimental impacts of solitary confinement. Other states, such as Colorado, are increasingly aware of the need for reform, and although change is slow to take hold, have publicly expressed intentions to work on reform. recognition of the adverse physical, mental, and emotional impacts of solitary confinement, and the development of procedures to safeguard against its application, especially for long and excessive periods of time, is the first step in reducing and ideally eliminating eventually this practice. However, solitary confinement still continues to be a pervasive issue in the United States, and more efforts are needed in order to bring the practice in compliance with international standards. First, the physical conditions and implementation of isolation must be proportional to the severity of the charges against the detainee. Second, solitary confinement must be imposed only as a last resort and for the shortest duration possible. Third, solitary confinement must never be imposed except where there is an affirmative determination that it will not result in severe mental or physical pain or suffering. Fourth, authorities should document all decisions, assessments, and justifications pertaining to solitary confinement and should communicate this to the detained person and his or her counsel. Additionally, persons held in solitary confinement must be provided with a genuine opportunity to challenge the nature and justification of their confinement through a process of administrative and judicial review, and be granted free access to competent legal counsel and medical services. I would like to conclude by once again thanking the National Religious Campaign Against Torture and the American Civil Liberties Union and other participating organizations who help organize this important event. I am also looking forward to the congressional hearing that we're going to witness this afternoon, and I'm hopeful that this gathering and that hearing will also help build upon the momentum spearheaded by activists, civil society organizations, and relatives of persons who are in solitary confinement, and by the persons who are in solitary confinement themselves, to help further public awareness and push for reforms on this important issue. Thank you very much.